Hi folks, and welcome back to Contract Law. This is video 4 in the video series on discharge of contracts. And in video 1 we laid the foundation. In video 2 we had a look at performance issues, discharge by performance, and particularly payment issues. In video 3 we had a look at discharge by agreement. And in this video we are going to look at frustration, which is probably appropriate for video number 4. And frustration is an interesting little doctrine that has grown up over the past 150 years or so. And it's designed to get the parties out of further performance of their contractual obligations where some supervening event, some event post-contract formation has kind of engulfed the parties, and there's no one's real fault, but it's really made the contract either impossible to perform or something radically different than that was originally anticipated. The test has kind of morphed over the years from a strict impossibility test to a more fuzzier chain in significance of the obligations test. But really, as I said, the essence of it is, as I say, the Cadell for Constructions test. There's no fault. Either party, the contractual obligations are incapable of being performed because there's something, the contract's now something really quite different. Because this doctrine can apply in almost any circumstance, you'll find there's just this plethora of case law, a lot of it in the 19th century for shipping cases actually. But because there are just so many varied facts that this doctrine has been applied to, it can seem a little bit overwhelming. Different texts treat this doctrine differently. I guess the best thing you can say is what I've said down the bottom there. It really depends on the facts of each case as to whether or not the doctrine will apply. Decisions have been grouped under headings the way I've done it here to give you a little bit more guidance to help you kind of flesh out where the limits of the doctrine are. I think the text treats it quite well. I'll be mainly guided by the text, but I like to group the cases under these headings because it's quite, I find it quite illustrative of the outer reaches of the doctrine in various different classic types of situations. So the first thing that we need to look at is the foundations of the doctrine's frustration. Harrington and Jane, case of, from 1647, is, I guess, the paradigm case showing why you really need a doctrine like this to help parties where these supervening events have occurred. So Jane, in that case, leased property from Harrington, and a German princeling invaded, and obviously Jane couldn't use the land. He stopped paying rent, and then, not surprisingly, Harrington sued. Unfortunately for Jane in that circumstance, it was held that Jane was liable. So even though that princeling had invaded and it was no one's fault and no one could stop it, and he physically couldn't perform the contract.
No, now go away or I shall taunt you a second time.
Unfortunately, still liable. So by mid-1800s, as I said, about 150, 170 years now we've had this doctrine going. A hall was hired for concerts, but it burnt down. And what happened there, I mean, if you applied the Harrington and Jane kind of hard-nosed approach, well, potentially, the parties might have made provision for the destruction of the hall hiring venue, but they didn't. And you could say that the hiring party should have been liable. No, in fact, they were not held liable. Why is that? The supervening event of the fire and the hall being destroyed made the contract performance impossible. And that was kind of the birth of the doctrine. So it's really quite a high benchmark to get out of your contractual obligations. They actually had to be impossible. Fast forward to 1956. Davis Contractors is the UK case that everyone cites in this area as the modern, I guess, ignition of this doctrine amongst the common law nations. In that particular case, we had a contract to build houses, and there were some very severe cost and time overruns due to factors that were beyond the builder's control. Now, in that particular circumstance, frustration was argued because the factors were beyond the builder's control. However, and this is where I said these cases flesh out the outer reaches of the doctrine, in that case the contract was not frustrated, and it was said that the test is radical difference, not hardship, inconvenience, or financial loss. So just the fact that there has been something that's happened that has made the contract a lot more onerous or expensive to perform doesn't mean that you can then use the exit door of the doctrine of frustration. You actually have to have the contract itself being rendered radically different from what you originally anticipated. And there, they still had to build the same buildings. It's just that it was, more onerous, as I said. So no radical difference there either. The other case that you could have a look at is the Sakharoglu case as well. So the Davis Contractors case was accepted by the High Court in our Cadelpha Constructions case, and that case is useful. We did it previously, but it's certainly useful in terms of validating the test from Davis, which was radical difference. So that is the way that the doctrine has kind of morphed from impossibility to radical difference, but it's not, as I said, a get out of jail free card or an exit door that you can use any old time when things get tough. Just mere financial loss or inconvenience isn't going to do it, because the actual contract itself needs to have been rendered radically different. That is the foundation of the doctrine. What about things like death or incapacity? Surely this must have some bearing on whether a contract is discharged. You might have death or incapacity frustrating a contract. In the Shepherd and Jerome case, we had an issue of jail. The apprentice there was an apprentice plumber, had 24 months left to run on his apprenticeship. He was sentenced, unfortunately for him, to a minimum of 6 months or a maximum 2 years imprisonment. That's just there, a bike gang fight. And his employer, after his release, refused to take him back. The court said, yes, we agree with the employer there. The contract had been frustrated. So in a similar kind of circumstance, Warlock deal, sailor sued for wages. The contract had been frustrated there by him being interned by Germans. So something similar again, discharged because of internment. If there's illness, then what you need to consider is the nature and the probable duration of the illness, and the terms and the nature of the contract. If it's a short spot contract and a prolonged illness, then in all probability you may well find the contract has been discharged for frustration. If it's quite a temporary or minor illness and the contract is of reasonable duration or even a short duration, you might find no frustration. So this is where I say it will turn very much on the facts of each case, and the court will forensically go through the factual matrix and work out, was the contract actually rendered radically different in performance here by this event or not? So you can't just make a blanket statement, well, wherever there's death or incapacity, there will be a frustrated contract. You really have to dig into the facts and see whether there is that radical difference underneath it all. Futility or failure of the basis of the contract. In this case here, Crell and Henry, it's kind of like, I call it a bookend case for Griffith and Brymer, which we had a look at in terms of common mistake. And I like this case because it shows you that frustration is the doctrine that will apply to get you out of your performance if the supervening event occurs after contract formation, and common mistake is the supervening or the event that will get you out of the contract if it happens before the contract formation. So it's similar need to get out of the contract or have the contract discharged. If the supervening event is after formation, go for frustration. If it's before formation, go for mistake. These cases are called the Coronation Cases because it revolved around the same event, and that was the royal coronation procession of Edward VII. In Crell and Henry, the defendant hired a flat from the plaintiff to view the procession. Unfortunately, because of his illness, which I think was appendicitis, the procession was cancelled. Now, because he had only hired the flat just to see the procession, the whole basis of the contract was frustrated. He couldn't actually do the very thing that the contract would have enabled him to do, which is see the procession. So the contract was frustrated. Griffith and Brymer occurred where the parties had made the contract, but little did they know, just before they had made the contract, the procession had been cancelled. That was a case of common mistake. Another of these coronation cases was the Herne Bay Steamboat case, and the same event, the coronation of Edward VII. There was going to be a big naval review in the harbour. There was a contract to charter party a ship to view this naval review around the celebrations regarding the coronation, and also to cruise around the naval fleet. So two-pronged basis of the contract. The review was cancelled because of the King's illness. Here the contract was not frustrated because the charter party ship could still be used to go around and view the naval fleet, even though there was no actual big celebratory performance by the fleet or manoeuvres by the fleet that they could view on the day. Nevertheless, they could still, sail around and see everything. So contract not frustrated there. Again, a good illustration of the outer reaches of where the doctrine will apply and where it won't apply. Okay. Cadell for construction is another of the cases that involved basically the failure of the basis of the contract. And in that case, that's the railway case where the construction crowd had been hired to build the railway for the New South Wales State Rail Authority, and the anticipated mode of working was basically, it was almost 24/7. The construction work involved significant blasting and a lot of noise, vibration, dust, disruption. Not surprisingly, the neighbours took umbrage at all of this. They got an injunction to enforce the construction at a more reasonable rate, and so they were unable to work on Sundays, and their shifts were restricted from the originally anticipated method of performance. The court said what you ended up here with was a method of performance that was completely different. The whole basis of the contract was to get this railway built quite quickly. In order to do that, you had to do this very intensive construction period. You can't do that, and now therefore you're winding up with something radically different. And so, given that the basis of the contract had been frustrated, the whole contract itself had been frustrated. So that is futility or failure of the basis of contract. Delay. Now this is a really tricky one. If delayed would render performance radically different from what was originally contemplated, it may well frustrate the contract. But again, this is one of those areas where you have to really look at the factual matrix carefully to work out whether or not there's going to be a conclusion of frustration or not. You need to look at the probable length of delay and how much time is left to run on the contract. You're going to assess whether or not the contract was frustrated at the time that the interruption occurred, because that's when you can put your hand up and say, the contract's been frustrated. So it doesn't matter after that whether or not the severity of the interruption was as bad as you thought it was going to be. What you have to do is make a realistic assessment at the time that the interruption occurred. So in Courtline and Danton Russell, we had a ship charter party that was ordered to go up 750 miles in the Yangtze River. This was during the war between China and Japan, and there was a certain period within which the charter party was to run. Japan created a blockade of the river, and no one kind of knew how long the blockage was going to remain for. And miraculously, someone breached the blockade and the ship was actually okay. It managed to sail back within time. Nevertheless, they put up their hand and said the charter party had been frustrated at the point at which the blockade occurred of the river. Now, at that point, the assessment, the realistic assessment was that no one knew how long the delay was going to last for, and it was more than likely going to run for longer than the time that was left to run on the contract. So to put your hand up at that point was perfectly reasonable. The charter party was held frustrated there. The Sakharoglu and Noglu case is a good case to compare to the Courtline case, again showing the outer reaches of the doctrine. In that case, we had 300 tonnes of Sudanese ground nuts that were sold by a seller to a purchaser. In that contract, the seller was to pay the cost of freight shipping the ground nuts from Port Sudan to Hamburg. There was no specified route in the contract, no specified delivery date in the contract, so no commonly agreed way to actually perform the contract itself. Unfortunately for the seller who was going to pay the cost of all of that, the Suez Canal was closed. That was the quickest, most convenient route. So it would have meant that the ship would have had to go via the Cape of Good Hope, which is far more dangerous, expensive, and involved a lot longer journey. The seller refused to complete on the basis that the contract had been frustrated. And the court said no frustration here, just because the contract performance has been rendered more inconvenient or costly, there's delays. It doesn't necessarily mean that there's going to be a radical difference in what was promised there, the obligation that had to be performed. There was nothing in the contract that required the ship to be sent via the Suez Canal, and so there was nothing else in the contract that could have performed an exit door for the seller there. So in that case, as I said, no frustration. So that's the issue of delay. The next issue to look at is illegality. We have passed that magical 15-minute mark again, and so I'll end this video here and I'll move it across to video 5. So I hope to catch you all in video 5. Bye for now, guys.